What's going on, everyone?
Hello, Brian.
How you doing?
I'm fine.
Good.
Did you see my man down in Georgia,
Which one?
Grandmaster Jay?
I didn't see him, but I saw a video.
Oh, all the people in black?
Yeah.
Yeah, that's him.
That's your guy?
Yeah.
You know him?
No, I just watch him.
Oh, good. Very good. All right, let's see.
Hey Brian, I got a couple of violations, man. So I think I'm ready to roll. I think I might have at least 3 E8 violations. I may have missed up when I didn't send a letter certified, but I do have where I communicated it through the CFPB. But
Okay.
but I think I'm pretty set.
Okay. Good. Well, we're talking about E8 tonight. Very good.
And I got 2 more that I'm just waiting on a correspondence back from that GB2 letter. Quite possibly we could probably go with it, but since I sent the GB2 letter, I just want to kind of see, what their next move is to, see if we actually got them, all the way to left in the corner. So.
Okay. Perfect. Excellent. Yes, we're about to talk about that right now.
Yeah, that E8 violation. I sent the letter certified. I got the receipt where they received it, and they have not updated it as disputed on the credit report. So I got
them. After how long of a time did you wait?
Let's see. I can pull it up right quick.
Mm-hmm.
All right, I sent it on 6/8. It delivered on the 13th of June, and I just pulled his report in Identity IQ. I want to say it was yesterday, and it had not updated.
Okay. All right. Well, it's been a month.
Yep.
So it should have updated by now for sure. You say that was certified or was not?
That particular one I did send certified. I got 2 more that I, unfortunately, for some reason, I was in letter stream, and I didn't send it certified, but it's the same company and it's the same thing. We sent the letter and they have not gone back and showed it as disputed or anything on the credit report.
Oh, okay. We can talk about that. All right, y'all. So good evening, everyone. Hope everyone's doing great. Tonight we're going to talk about the FDCPA, specifically 1692 E8 violation. So because it's the FDCPA, everyone should know this only applies to debt collectors. I was talking to someone today about these types of cases, and they were like, well, what about this particular business debt that got placed on my personal credit? And if I dispute it, is there a violation? No. So keep in mind, you have to go back to the definitions. And even when you're dealing with debt collectors that land on the personal credit report, you always have to keep in mind it only applies to consumer debt. So even when it's a debt collector involved on your personal report, if the underlying debt is for like a business personal guaranteed card, that does not activate the provisions of the FDCPA. So keep that in mind. It has to be debt under the FDCPA, which is a personal, family, or household purpose consumer debt. So keep that in mind. And as far as debt collectors, we all know when we're dealing with a debt collector, there are some exceptions and some tricks to it, but for the most part, most of you will be familiar with what a debt collector is. You have an original creditor, and then you have a debt collector, and then you have some exceptions to the rules. Here's some exceptions to the rules. Does not include these people, but for the most part, everyone may be pretty clear on when it's a debt collector or not. If you're not, then we have to study it, so we sort of cross that bridge when you see it. Let's see here. All right, so we want to make sure it's a consumer debt. We want to make sure you're dealing with a debt collector. That's just so you're not wasting your time even evaluating it or going through this whole process of disputing it. Vance is not on tonight. Vance likes to do these by phone. Maybe tomorrow, so we'll have him come on and talk about, he has a telephone script that has been working very consistently. I don't like deploying consumers to talk to debt collectors personally, but Vance has a nice script that he coaches people with, and I'll let him talk to you all about that another day. But as far as I'm concerned, I'm going to deal with you all from a written dispute angle, and of course, if you're doing the oral, you want to record that. Now, of course, if you're doing a written, you don't have to, but I highly recommend that you send it certified mail. And we remember on the repo lectures how they have to prove they sent it to you. Well, the reverse is true when you're coming after these debt collectors trying to get relief against them. You may find yourself in a position of trying to prove that you sent the dispute and when you sent it, etc., that they got it. Because not only do you send it, what if they didn't get it? Well, you can prove by evidence that they got it if you have certified certified mail. Sometimes I don't do the return receipt because the certified mail is tracked. So with the certified mail tracking number, you can show when it's delivered. Now, if you want to get real particular, you can keep the return receipt portion, have someone sign for it, and now you can really seal the deal and have a signed confirmation that not only was it mailed and delivered, it was signed for. I typically omit the signature part of it. I'm pretty comfortable with just the tracking, but one day I may have an issue where they say, well, it was delivered. I don't, so when I think of it, I may start even leaving that signature in there and not trying to save $1.40. But if you want full protection and full coverage, let them sign for it. But anyway, highly recommend you do that, because if you send it regular mail, all you can do is do an affidavit to prove that you sent it, which is admissible. But again, it's always great to have third-party evidence like the Postal Service confirming that you sent something. And I use the letter stream, so you can easily go in there and pull, and then go to USPS.gov and pull the tracking. And so tonight we're going to talk about E8. So E8 is about false or misleading representations. And a debt collector may not use false, deceptive, or misleading representation or means in connection with collection of any debt without limiting the general application of foregoing the following is a violation. So this is the law, and then here are some examples. And it's not an exhaustive list. I mean, it's not everything, but these, if this happens, this is a violation of E8. Go down to E8, communicating or threatening to communicate to any person credit information which is known or which should be known to be false, including the failure to failure to communicate that a debt is disputed. And so read that to yourself one time again. That's a very important rule. I had a little section about this. It's E8. I want to show y'all something about E8 or read something to you. Let's see, E8. E8. All right, so I'm gonna read something from my NCLC book regarding E8. And I'll take it, let me see. I'm about to take a picture of it. Send it to y'all too. All right. Send it to you.
I'm sorry, Brian, what is E8?
15 U.S.C. 1692 E.
Okay.
And then going down to number 8. So when I'm saying E8, I'm talking about 15 U.S.C. 1692 E8. All right, let's see if I can open this up. So let me see if I might be able to share this. Stop share. Okay, so y'all see this screen here? I can see that. I'm gonna read it. This provision, and we're talking about 15 U.S.C. 1692 E8, does not give debt collectors the authority to determine unilaterally that a dispute lacks merit and not be reported. The debt collector must communicate that a disputed debt is disputed. We see that word must. And there's a case that says that. They must do it. The Seventh Circuit, that Seventh Circuit is like Indiana area, Illinois, construing another provision of FDCPA, held that a consumer is not required to use legally precise or sophisticated language to assert FDCPA protections. So very important. So a lot of you wonder, well, what do I say? What do I have to say? You know, it doesn't have to be precise. The consumer's inquiry about the basis for the additional client charges was an oral dispute of that charge. So very important. Afterwards, the collector should not report the debt to credit bureau. I don't know why they write it like that. With consumer reporting agencies without also reporting the account as disputed. Okay, So that's very, very important. So that paragraph I really wanted y'all to see there.
One question on that, Brian.
Mm-hmm.
On that, it says market disputed. Can it say anything else that would be suffice? Like customer disputes, something like that? Or should it just say disputed?
It really has the word, the statute says, it really needs to say it's disputed.
Yeah.
But, I mean, if they use some other language, it better be a real close synonym for the word disputed.
Okay.
It does not agree. I mean, I could imagine something.
And sometimes they'll say the customer disputes, but FDCPA, something like that, agrees, does not agree with, or something like that.
Yeah, I've seen that, but yeah, really want to see that word disputed. If it's anything else, you want to sort of see if a reasonable person could sort of easily interpret that it means disputed.
Okay.
Let me read it.
So, but it has to come from a third party, not the consumer, right?
What has
when you dispute it, you dispute it as a third party, right? Not as the consumer.
No, the consumer's disputing it him or herself.
Okay. Not the what do you call it? The counsel for, like, we all have other companies besides our credit repair companies, and that's how we go through them to dispute instead of directly through the consumer. So we go through that company, not the consumer. Correct?
Brian, I think he's talking about if he has an attorney or CFP.
Not an attorney. I mean, I think when we send third-party letters, we send it through another company or under our another DBA.
Give me an example.
Like when I dispute with the creditors or the collectors, I go through my other company, which is Abrams, Feinberg, and Sachs. I don't go through Certified Credit Consultants, which is my credit repair company. I go through them.
Okay, for a consumer or for yourself?
No, for the consumer.
Oh, okay.
What he's saying, you outsourcing your credit repair?
No, I'm not outsourcing at all.
Oh, okay.
I have another DBA, which is basically Abrams, Feinberg, and Sachs, which sends letters to the creditors that we are representing the client.
Oh, okay. As their power of attorney?
Power of attorney, yes.
Oh, okay.
That, that they need to communicate with us and not the consumer anymore.
And you provide them with the power of attorney authorization?
I do.
Oh,
yeah,
okay.
absolutely.
Yeah. So to answer your question, I think I would prefer you say it includes a third party dispute as well. So it's, the consumer contacting them, a lawyer like me contacting them, a third party power of attorney in fact, like yourself contacting them.
Right.
All of those apply. Obviously,
all right.
Third party, has the, authorization to submit it, like you're submitting your power of attorney, I'm submitting my authorization form. But yeah, all of that would trigger E8. It would trigger a dispute. So yes, third parties included.
All right. Perfect. Thank you, man.
So let me see. I think that paragraph was good. Okay, so yeah, so that's it for that paragraph. So yeah, the purpose of that paragraph I just showed you was that, it doesn't have to be any fancy language. You don't even have to use the word dispute. Vance will talk to you about oral disputes maybe tomorrow. but you don't have to use disputes like that paragraph I named. Just an inquiry. For example, you can say, I don't agree with that balance. I don't know how you came up with that. That's all a dispute. It doesn't have to be precise to say, I dispute that debt.
Brian, I got another question.
Sure.
This company here in Texas, Business and Professional Services, it normally is for medical accounts, normally.
Mm-hmm.
And I sent a third-party letter saying that, from my other company, saying that, I need you to give me the details and the account details and all that stuff. And they came back with a letter saying that your dispute is untimely and that the 30-day validation period is over. Now, I'm sure, or maybe my client did get a letter from them maybe 2 years ago, 3 years ago.
This is the company you're
But
talking about? Business and Professional Collection Service?
yeah, Business and
In
Professional.
Nevada. Okay, good.
And I don't know. I think they're right here in San Antonio, Texas.
Oh, no, Texas. All right. But go ahead.
So basically, when they say it's untimely, obviously the account was 3 years old.
I see.
And we saw it on the credit report, and I asked them to provide me the validation. I sent a validation of debt letter, and they say your letter is untimely because you didn't do it in the 30 days by law. How do you go about that? Obviously, maybe the account was in 2000. It went into collection in 2017, but I got the client in June 2020.
Okay,
So
so
if I
walk
send
me
that letter,
me through how would you evaluate your question? What do you think we need to look at?
well, when they're saying it's untimely and that you are outside the 30-day validation period, how do you go about it? What do you do?
Okay. Do you know what period they are referring to?
I think 2017, if I'm not wrong.
Well, do you know what statutory period or what rule they're relying on?
1692.
Well, let Muzi work it a little bit here. I'm trying to let Muzi work it a little bit.
Okay.
I have no clue as far as the law is concerned. Let me take a look at the letter. And it was so frustrating. I was telling Matt Listro and Neil and all, I was like, man, I'm frustrated. I feel like, I lost my confidence here.
All right, we're going to
these guys are
confidence real quick. So how long you been with us? Because I forget.
With your WhatsApp group and all that?
Yeah.
Well, honestly speaking, don't kill me, but I haven't even started.
Oh, okay.
I have.
What I'm saying,
I keep getting your WhatsApp messages, but I really need to work on that. And I have it in my schedule to work on Brian's training today.
No, I'm just I'm just wondering if have you at least dabbled with the 1692 GB letters? Not yet.
That's.
I'm just asking. I'm trying to understand where you are in knowledge of this types of stuff. All right.
No, I haven't. All right,
cool.
Speaking.
So I got you. I'm just understanding. I don't want to speak Mandarin to you if you if you don't speak Mandarin type thing. So well, first of all, they're referring to the FDCPA, right?
Right.
You're dealing with a debt collector.
Correct.
What section of the FDCPA they're referring to? Noble mentioned they're referring to G. Because look at the FDCPA.
Yes.
It's not that long.
They're referring to G. No doubt about it. 1692G.
Validation of debts. All right, let's click G. Now we look at G. We have a GA. We have a GB. We have a GC. We have a GB. We have a GE. Now I have a GED. obviously. All right. That wasn't funny, y'all.
Yeah, that's what they're referring to. 15 U.S.C. 1692G.
All right. So the
It's-
30 days they're referring to, if you look at GB, it says if the consumer notifies the debt collector in writing within the 30-day period in subsection A, here's A, that the debt or any portion thereof is disputed, or that the customer requests the name and address of the original creditor, the debt collector shall means they must do it, cease collection or any disputed portion thereof until the debt collector obtains verification of the debt, or copy of the judgment or name and address, and a copy of such verification, etc., is mailed to the consumer. All right. So the 30-day period, subsection A.
1692A, right?
So let's look up in A. So you follow me what I just read, right?
Yeah.
All right. It says subsection A. Subsection A is notice of debt and its contents within 5 days after the initial communication with the consumer. So initial communication, communication is anything, be a phone call, letter with the consumer in connection with the collection of any debt. A debt collector shall, they must do it, unless the following information is in the initial communication, or the consumer has paid the debt, send the consumer a written notice containing the amount of these 5 things. It's 5 things. And if you look at the 5, when you see a list, look and see if there's an and or or. There's an and. So all these 5 things have to be satisfied. 1, the amount of the debt, name of the creditor, to whom it's owed, a statement that unless the consumer within 30 days after receipt disputes the debt or any portion, the debt will be assumed valid. A statement that if the consumer notifies the debt collector in writing within the 30-day period, they'll obtain verification and mail it. And 5, a statement that upon the consumer's written request during the 30-day period, the collector will provide the name, address, of the original creditor. All right. So they're talking about a 30-day period in which this notice is provided. And so this notice can be in the very first letter or to the consumer, or a letter within 5 days. So let's assume your consumer, you said this debt was owed, right?
Mm-hmm.
Well, technically, we would want to know, what would you want to know? I would want to know if the consumer ever got a letter from them.
Right, exactly.
So that would be the question you would ask your consumer. Have you ever heard from this debt collector? If the answer is yes, well, do you have a copy of that letter? Well, they may not. So your analysis would be whether he or she has heard from debt collector. If so, you want to see a copy of that letter. Because what if you have a copy of the letter or letters, and you certainly have the first letter or any subsequent letter, and it doesn't have this notice in here, then that initial communication period, notice period, had to start it. So that's the analysis. So from what you're telling me, their position is we initially communicated with her and gave the notice of debt under GA a long time ago, and your request is untimely, which means they don't have to complete the verification process.
Correct.
Okay, does that make sense now?
Absolutely.
So that's what we're talking about. So if you want to further go into that, you would talk to your client and see if they ever got anything from that person, that company, ever. And if they did, do they have a copy? If they adamantly say they never got anything from that debt collector, then you could go back to that debt collector and say, listen, I understand you believe you're outside that the verification request is untimely. However, there's never been an initial communication with the consumer. And if I'm a remiss, send me a copy of it and proof that it was ever sent. Sufficient proof would be certified mail return receipt or an affidavit of the person who sent it, because my client never received it.
Okay.
So
and that's the route I was thinking of going.
That's what you can do. All right. That's what you can do. Now, let me ask you this. What letter did you send them?
No, I just got it. I just got it. I
No, no,
haven't
no.
sent them anything.
Well, you got to get that kind of response, you had to send
Yeah,
something
yeah.
already. So I'm asking,
Basically,
what you,
validation of debt. Validation of debt.
did you just
Basically
ask for
asking.
validation, or did you state that you disagree, or the consumer disagrees with it?
No, no, I didn't say anything like that. I just
All right.
wanted them to let me know the account numbers and the whatever they have on it, and if they are authorized to even collect uh, in the state of Texas. Let me look up that account. Let me look up what the letter that I sent them.
All right. Do you have a copy of my book and the GB letter?
I need to get the copy of your book, man. How do I go about it? Where do I get it?
You have to go to the mall, to Barnes and Noble.
Get out of here. Seriously?
No, I'm just joking.
Amazon?
Yeah.
Okay, I'll get it. I'll certainly get it.
I'm about to pull it up. Yeah, I'm about to pull it up.
Yeah, the letter I sent them basically said, that we are working with this client, a copy of the contract that created the account, a list of goods or services that were provided, and proof of delivery, monthly statements showing the charges you wish to collect, proof that you now own or are assignee of this account, verification of the copy of judgment if applicable, name of the original creditor, if licensed to collect debt in the state, your license numbers, registered agent information, etc.
Mm-hmm. Yeah. So I in the WhatsApp chat, I put the link. Oops, no, I got put the link to the book. I did put the link to the book, but you just email me your receipt and I'll send you the bonus.
Great. I'll
But,
certainly get it, man.
but yeah, you want to consider the GB letter because you ultimately want to ask for an agreement too. Your letter, I suggest when you're in the process of trying to get validation or verification, wherever the case may be, that you take that opportunity to express some disagreement with that debt of some sort, or some type of challenge or something. Because just asking for what you just read, I don't think that qualifies as a dispute. Because guess what? If you did include some language like I do that disagrees with it, says that the consumer does not believe they owe that amount, or they don't know how that amount was calculated, or something like I just described, it's going to trigger, even if it's outside of the GB period, it's going to trigger E8, right? What we just discussed.
Okay.
Right? So your letter just asking for all of those details and things, I didn't really hear anything in there that took issue with the debt itself. You asked for their licensing and their this and their that verification, but you didn't say anything about disagreeing with what they're trying to collect. So you have some dead time, even if you're asking for verification, but you add some dispute language, you're going to trigger E8 no matter what the result is. So that letter you're getting back, you actually have dead time now. You can't really sue under E8 right now or activate E8 so far, because your letter didn't include any language to cause that to be activated.
To basically dispute the whole thing.
Well, I have a GB letter that has language that satisfies it. It does
in your book, or
dispute the whole thing. Yeah, it literally says person doesn't agree they owe that amount. So that does count as a dispute. But
it's in your book?
Yeah, and it's a bonus. It's a letter in the book, and we've updated this letter. You'll get it as a bonus letter.
All right, perfect. Yeah, I'm gonna get the book tonight. You sent me a link, right?
It's on WhatsApp.
Okay, perfect. I'm gonna get it tonight.
So I think everybody else is asleep because this is some review for them. Warren, can you wake up, please?
While you're at it, can you help me with a personal issue?
Go ahead.
A constable came to my house today, and
Live in London?
huh?
Go ahead.
Well, I had a Mako franchise. Are you familiar with Mako, the paint and body shop?
Mm-hmm.
Okay. So about 15 years ago, it went belly up. I owed about
This is a business
$500,000.
debt. We can't talk about that here.
No, the corporate wheel got broken somehow, and they came after my wife. It's Palisades Collection, because my wife is a physician, so they knew that they could collect from her. So the corporate wheel somehow got broken. Maybe I didn't file the what do you call it, the franchise tax or whatever, and it got broken. And so they came after my wife, and they filed a judgment about 15 years ago. And my wife is a physician. She's got her own corporation. She got the PPP loan, and somehow, all of a sudden, after 15 years, these guys became active. And they're coming after me. They're trying to give her a writ of execution. We don't have anything, honestly speaking. There's nothing they can do, especially here in Texas. How do I go about it? What's the best way to I mean, you're an attorney. So
This is regarding the Mako debt?
It's a Mako debt, but as I said, the corporate wheel got broken. And instead of filing it on Mako, they filed it on my wife, who was a silent partner. I mean, the corporation was me and her. And they filed it, after the corporate wheel was broken, the Mako was, went upside down, got closed and everything. Yeah. They filed it against her, not against me, because they knew she's a physician. She makes money.
What state is the judgment?
Texas.
Texas. Oh yeah. So yeah, you can get a debt defense lawyer. Sounds like a business debt, but obviously that thing is reduced to judgment. If they have a writ and against her, and if she's a working doctor, they're gonna get to her money, to her employer very soon. So yeah, you will want to get a debt defense lawyer, and with that being reduced to judgment already, a Texas lawyer can tell you if it's too late or not to vacate that judgment, or if you're stuck at a point of negotiating it. So, but that's beyond the scope of us, because it's not really, none of this that you've mentioned is consumer. I mean, it's on the credit, possibly it still has some.
I got it out of her credit report.
Excellent.
Credit report is gone. The only thing is that.
Yeah, I heard it. I heard you. She needs a lawyer to help her deal with that judgment, because they're going to find her money and she's not going to be happy. So,
no, I mean, her personal account, her business account, she's got a new corporate LLC, PLLC, so they can't come after her business.
Yeah, we're gonna have to cut that discussion short. This is beyond the scope of our training.
Yeah,
that you need to find a Texas lawyer. We can't talk about that anymore here.
Mm-hmm. Sounds good. Thanks, buddy.
All right. I was about to call Warren's wife to get you.
Who's that?
Now I was about to, nothing. But yeah, get a debt defense lawyer on that one. Now
I'm thinking of just calling them tomorrow, because I had about $80,000 from IRS.
All right.
And they found me insolvent. They got rid of it. I'm scot-free. $180,000 from IRS.
Awesome.
I think I deserve to be garlanded or something. If you don't pay $180,000 to IRS, I think that's a feat.
All right, music. We have to get off of this. We're not a tax talk. We have to get back to E8. So so in light of what we've talked about tonight, when you see a collection on a credit report, first of all, you all want to have some type of credit monitoring. And if you're using Credit Karma, fine. My FICO, fine. But you want to get a credit snapshot. So if you're on Credit Karma, when you open up this collection, you want to take a screenshot of it. If you're using My FICO, you want to print out and get documentation of how this trade line is reporting before you submit your disputes. So say if you're doing a 1692 GB letter, you want to always have a snapshot of how the reporting is. You do that letter, you see it's delivered, give it a month. A month later, you want to go back. Well, first of all, you hope it's deleted, right? And so remember, we hope these things are deleted. But what if they're not? If they're not, this thing better be marked disputed. If it's not, you have an E8 claim. All right, so this is another tool for your toolbox for when they don't do the right thing. You have an E8 claim if that thing is not marked disputed.
What about IDIQ reports?
Yeah, anything. So IDIQ. So you want to print that, screenshot it, whatever you can do to preserve the pre-dispute nature of it to see what it says. The comment section won't have anything. And then a month after this dispute, of course, ideally, hopefully it's deleted. What if it's not deleted? Well, it better be marked disputed. If it's not,
so
violation.
Do you send it to the creditor, or do you send it to the bureaus?
What we're talking about, this dispute goes to the debt collectors.
Okay, so you send it to the IDIQ report. You send it, like, for example, date of last activity is not correct. You send it to the creditor or the collector.
We're not talking about sending the report. We're talking about taking a snapshot of the report for our records to prove in the future or to show when the time comes that the debt collector did not mark it disputed for our own records. Because ultimately, if we have to sue them under E8, we want to have evidence to show, look, before I disputed it, it wasn't marked disputed. After I disputed it, it still wasn't. That's the violation. So it's evidence. It's not something we're mailing to anyone. The reports are for our own record and evidence that what we're saying is true. They failed to mark it disputed.
Perfect.
After a reasonable time has passed. Reasonable time to me would be a few days, but a month later, it should certainly be marked disputed.
Perfect. Excellent.
So, Brian, how do we address it when we have I have a collection that was sent to me? Well, they sent a dunning letter to me, but before it's still not on my credit report, but I've replied with a GB to them.
It's not on your report?
No, it's not on my, right now, it's not on my report.
You sent a GB, right?
Yes, I did.
How long ago was it received?
It was received last week.
So what you expect, if it's the newer GB, you expect them to get to you and say they're going to delete it, right?
Well, that's what I'm hoping now, because actually what happened, I listed, because I have like a junk email address and then I have a business email.
Mm-hmm.
On this GB, I sent of course, my business email. Mm-hmm. Well, I just happened to be checking last Friday. I would happen to be checking my junk email, and they replied to the junk email.
Okay, what did it say?
I didn't even open it. I chose not to open it because it's password. They want me to enter a password. So I was going to ask you, do I look at it from that aspect, or do I expect them to reply to the email that I supplied them?
Open it now and let us know what it says. Yeah, that's good. Yeah, don't be afraid to open the email. Warren, you're afraid to open that mail from debt collector?
No way. I want to get letters from every day if I could.
Hey, Warren. Warren's gonna be paid on y'all. At this point, you all, we're not afraid to open emails from debt collectors. and we are happy to open mail from them. Happy. Oh my goodness. I wish a debt collector would send me something. I really would. I'm in the process of getting that also. I like that. But yeah, no, we're gonna open it. We open that letter. The reason password protected because if they accidentally send it to Noble, they don't want Noble, answer, open it, So it password protected, probably asking for, you to enter something unique.
Okay. This letter is to inform you of a special offer on the collection listed above. Our client wants our recs to reflect that we made an attempt to resolve this matter. Please see the options listed below.
What do you think, Warren?
I want to get something like that.
You're a rich man.
Well, tell me this.
Sounds like a CC.
Was this sent to you after they got your letter?
Absolutely, yes.
All right, go ahead, continue reading.
Oh, that's nice.
Yeah.
Go ahead.
Let's see. Our client wants our records to reflect that you have made every attempt to resolve this matter. Please see the options listed below, approved by our client at this time. Take advantage of a 50% off the current balance, make a one-time payment on or before July 20th. Take advantage of a discount of up to 40% off current balance, make 3 payments, first due July 20, then August and September 20. And it continues to where I could take up to 9 payments and go through March 2021.
What's the name of the company?
Valentine and Kebartus.
Kebartus?
Yeah, Kebartas.
I see him.
So they're not a debt buyer, right?
They said that they're working on behalf of LVNV. I directly disputed this at the CRAs, and it was deleted, the LVNV. So I guess I'm not sure what's happening, but anyway, it's not my intent to have to pay money.
In Massachusetts?
Yes, Lawrence, Massachusetts.
How much are you trying to collect?
They said $894.
$894. So you tell me what you think. What you think about this? $894.
What do I think about it?
Yeah, like, do you see a violation?
With them offering a settlement?
Yeah.
I would need to read again.
All right. What we need to read? What section? Well, let me ask you this. What made you write them Valentine? Did you write Valentine?
I did. They sent me a letter.
Was it the first letter from them?
Yes, it was first letter from them.
When was that? What month?
Hold on, let me grab it.
Approximately.
It was approximately June. I mean, because I replied within 30 days.
And you replied within 30 days, and they sent you that in response to your email.
Right. The letter that they sent me is dated June 8th of 20.
And when did they? All right, that's the first letter they sent you, June 8th.
Yes, June 8th of 20.
And then they got your letter, your dispute letter. What day?
It was. I would have to check my mail. I got my receipt, but it was last week.
Last week. And then this email came when?
Last Thursday.
After they got your letter?
Yes.
Okay. Okay.
No,
they didn't have your email before this letter, so they obviously, I would say, they got your letter and got your email that way.
Yes. Because I'm assuming that they got my junk email from the original creditor. I mean, that's just an assumption. I don't know.
Well, that's not a good assumption because we're hoping they got it from that letter, right? But you're going to have to sort of find that your receipt.
Oh, I mean, I can put my hands on the receipt and look it up.
Yeah, so what I'm interested in, and I hope you understand why, is when they got your letter, your dispute letter, and then they sent.
Okay, it'll take me about 2 minutes to put my hands on the receipt.
Go before, okay, go ahead. So obviously Warren sees this. Everybody else hopefully.
Yeah. Yeah.
See, I'm looking at when they got that letter, they have to cease collection. What he was reading was a collection attempt, that settlement attempt. So you shall see. So they violated what? What section of the FDCPA did they violate? If what he's saying is true timeline wise.
That'd be that GB.
That's
Correct.
a 1692 GB violation.
Correct. Because what
it's within 30 days.
Not only that, no, it's because they continue to collect. They shall cease communication until they send verification. What he read me was not verification.
Let me mention one thing, Brian.
Mm-hmm.
One observation I got from what he said is that email he provided them on that letter that they didn't have before.
I know, but he threw a monkey wrench in there talking about he thinks it may come from
the original creditor.
It doesn't really matter if they receive that letter. They should have immediately put the brakes on all systems until they do verification. Put the brakes on it.
And this is called overshadowing.
It's called not ceasing communication. Not ceasing collection until you do verification. Until you mail the verification.
Okay.
But you may consider it overshadowing, but it's not. It's failure to cease collection.
Okay, here, I sent my letter out on the 6th. Post office says they received it on the 13th. And the email was sent on the 9th.
June 9th?
Yeah, the email that they sent me was sent out on July 9th.
And they
it says they received my letter on July 13th.
Oh. They got your 1692 GB letter on July 13th?
Yes, which I did yesterday.
All right, well, all right, so yeah, so technically there's no violation with the timing. You should not receive anything like that from them without them having sent the verification. Did you send the updated 1692 GB?
I did, yes. I did send the updated GB.
All right. Look at that there. Yeah. Up to eBay. Well, that's a monkey wrench in that particular claim. But so you just wait to see if they send your verification. They can ignore everything and just not proceed in it. Did you say you got it off your credit from LVNV, right?
I did, yes.
And it's just this Veritas, what's it called, Valentine, and they are not a debt. They're a debt collector. Okay. I don't think. Yeah. All right. So yeah. So keep your file together. Keep it in your computer. These dates are very important. That's why I use LetterStream, because I can just keep it online. But yeah, keep those dates. I mean, I'm just taking notes here. So keep a little sort of timeline when you get your letter, you send your 1692 GB. You want to mark when they got it. When you hear back from them, you want to read it like you read it to see if it's a collection letter or a verification
Okay.
letter. And that's how you sort of evaluate what you got there. So we've evaluated what you got there. We've determined that their email preceded their receipt of your letter, so it doesn't violate. Now, did you evaluate their first and second letter communication with GA? Did their first letter have all the GA notifications in it, notices?
No, it did not.
What about the email?
The email that I just read did not have the 5. Wait a minute, let me look.
I didn't hear the Miranda either.
Yeah. So let me just, for the sake of time, because we have 5 minutes, we will take some other questions, but scrub that first letter to see if it has everything in GA. Scrub that email to see if it has the notice of debt, 5 things in GA. As Richard just mentioned, go to make sure it has the memoranda to state that they're a debt collector and all that stuff, and anything used for that purpose in that first communication, and in the second communication by email, it needs to say that they are a debt collector.
Okay, I'll make sure that I read them intently.
Mm-hmm. And if it doesn't have that GA in either that first letter or that email, forward all that to me. That's a violation of GA.
Okay.
And you can be compensated on that.
Brian, are you licensed to practice in Texas?
Federal court, yes. State.
So for bankruptcies only, right? Or
I could. I'm not registered with the bankruptcy court. The court, I don't do bankruptcy there.
So, I mean, if there's a lawsuit, can you practice in Texas?
Only federal court.
Only federal court,
So
not a state.
I can sue people there in the federal court.
Okay, but not like state, if it's San Antonio, Texas, Bexar County or anything, right?
State, no, I can't do anything there.
All right.
Mm-hmm.
But I'll reach out to you just in case.
Okay. Yeah. So everyone understand what we got going on here with this E8? You see how that?
Yeah, and it actually makes it more clear. Because when I was finding disputes, I was actually using when they weren't noting the dispute inside the comments or anything like that. When the account was in dispute, I was actually using that 15 U.S.C. 1681 S2, and I think it's like 3 or 5 or something like that. Mm-hmm. Where when they're reporting, they are supposed to note the account is in dispute. Mm-hmm. So this actually helps, with the debt collectors even more, because the debt collectors also become a reporter when they report to the consumer reporting agencies as well, when they take over, become a debt buyer. Mm-hmm. So this actually helps a lot better.
Mm-hmm. So yeah, if y'all hadn't figured it out yet, there's so many ways, there's so many terms they have to comply with, so even if they don't just delete it, if they don't mark that thing disputed, boom, you got them. And
what about, I got a question now, Brian. On his letter, what about the any debt, those different values they're giving him?
What about them?
Are they a violation of, is it F1? F1?
Well, you talk to me about F1, I think anything's a violation of F1 unless you got an agreement in my hand supporting that debt. I mean, F1 out the gate. Mm-hmm. but when he sends that GB and he doesn't get an agreement back,
You really got it.
yeah, that sort of helps you with that form. So we're just, you know, getting this thing lined up for a violation. So they don't delete it. You may have a GA violation. It sounds like you have to scrub that letter. I mean, most letters, it's the most basic thing. So with that company, it looks halfway established. I mean, I would be very surprised, but very well that first letter, you gotta look on the back too. Not sometimes to fill in the back.
Right.
It seems like it should be a GA notice on there.
There's no attachment on his email. I don't know if he's still on.
I am still on. The actual attachment was the settlement offer that they sent.
Okay.
I mean, and really besides that, there's really nothing.
Is it a PDF?
Yes.
Oh, wow.
Yeah, be sure to save that PDF, of course. Save that PDF. Well, anyway, so when we get off, you study that PDF, and then you study that initial letter that you got. We obviously passed the 5-day mark, so it needs to be in one of those 2 items at this point in time, because if it's not there, then you should be emailing me saying, "Hey man, this is a GA violation," and then possibly, as someone mentioned, E11. Wait, no, maybe not E11, but yeah, E11. That's E, failure, debt collector, attempt to collect debt, all that crap. E11. So yeah. So we are making progress. We got a lot of these cases I'm typing up. Some of you can expect to get retainer agreements from me tomorrow and throughout the week for the cases you've sent. Only a couple have said they are ready to go on their own case, standalone, and then the ones that have not, I'm assuming you all need some filing help and want me to try to pair other plaintiffs with you, and that's what I'm working on.
I got a question.
Yeah.
So in that example, if the violation is clear, like after he reviews everything, would your suggestion be the next step to send a demand, or you go straight to litigation?
I would recommend litigation of it. I mean, if I were to send a demand, I would highly recommend litigation. It's clear,
Okay.
a clear violation, because yeah, I would recommend litigation.
So is it kind of like a case by case where you kind of assess if you do demand versus litigation, like as far as your steps?
Yeah, it is case by case. A demand, it's not on this credit. Okay, sometimes when stuff is on the credit, I start off with a demand to give them a chance to do that. It's not about credit. It's about a clear violation of GA. It's not on the credit, so I don't want to demand, I don't need to demand for it to come off the credit or else. So it's a straight up violation. So I could send a demand saying, hey, send $1,000. It's COVID-19 season. Nobody's trying to send $1,000 voluntarily, right? So, but if you sue them, well, they're gonna have to give their insurance company $5,000, $10,000 to activate their liability insurance. So that's a bet. They're more likely to drop $1,000 plus check in the mail with that. So you see how, you consider all those things. In a situation like that, yeah, it would be best just to sue.
And would you suggest keeping a state level in something like that, or do you go straight for a federal? Like, is there one court easier to handle over another, or?
In situations, if I'm doing
I know that the filing fee is higher.
Yeah, so when I do it, I would recommend federal court. If I'm representing him, it would be federal court. If he were doing it, I would recommend that he do it in a state small claims court. And for those of you that haven't heard, when you do that, you want to add some type of state law so it's not removed to federal court, because the small claims court is designed for people do it yourself.
Okay, that makes sense.
So, yeah.
Brian, for us considering handling some of our own cases in small claims, would you recommend that we actually go to these courts and kind of become somewhat familiar with proceedings?
I've been preaching that every day, to get familiar with the rules, the forms, the website.
Well, and I understand that part, but I'm talking about actually physically going in court, watching activity.
Oh yeah, that would be great.
To kind of become familiar with protocol.
Yeah, I mean, you have to check with courts now. I mean, if courts are allowing people in, I mean, but some of your courts may be online now with Zoom or something, so you can check with the COVID-19. But yeah, if you have opportunity to go check it out and see some of these cases and see how it sort of works in there, I would certainly do that. I mean, it's like y'all in law school right now, and that's what we did. We go down and just sort of take a look, see how things go. See how things go, and yeah, like I said, some of them may be online. All right, any other questions? Who we got here? We got, is Tony from Houston on here? I thought I heard somebody say he had a question. I like Tony. So the Tony Houston Award tonight goes to Muniz. Congratulations. Warren, you don't get it. Nobody gets it. Well, Tony usually has the most questions. You don't get my joke?
Yeah.
Yes.
Yeah.
It's dry as the desert, huh?
I got the GED one a little better.
Yep. Nobody laughing at me though. Isn't that a site note? All these violations, y'all. I mean, it's like, I mean, you still,
Yeah, I'm gonna send out some more CCs here the next day or two.
Yep. And so for some of you, that's awesome. So some of you that have, it's like if this the GB, it has so many prongs on it. We're setting up our F1. We need that agreement. We're setting up our E8. They better mark it disputed. We're triggering GB if it's timely, right? Like what we talk about now. So that's, you get to appreciate all the words in that letter. So that's that. Any other questions about anything else?
I have a question. Brian, I got a quick one too.
Okay, whoever first. Okay.
What is the repercussions? Like, I sent out a 1K demand letter for inquiry, but then on the bottom we have the CCCFP and then my state attorney general. Well, I realized I didn't fax that over. What are the repercussions for not actually faxing that out? Are we still able to proceed with the lawsuit, or if we put CC, we got it?
It's never too late to send it. You can send it right now. But yeah, there's no repercussion. I mean, you don't have to copy who you say you're copying, but you want to intend to do that. I mean, otherwise you just sort of bluffing. But I would send it. I would send it now that you forget to send it. Well, go ahead and send it. Or remove it next time if you're not going to send it. But I recommend it be sent. That's what it's there for. Next person.
All right, that was me, Brian.
Yeah.
Hey, I sent I got a client that has it's Midland funding.
Yep.
And it was credit card charge loss, but I sent the 1692 GB letter out. Mm-hmm. And I copied in the CFPB, and it took them a minute. Like in the comments in the CFPB, they was like, "Hey, we're gathering information and we'll respond back." But in their response, they sent like a it was this big long response, and basically what it said was that they're gonna cease communication, but it was saying, hey, you owe these debts, and here's, they sent the credit card statements like they normally do. So I was in the process of going with the 1692 GB2 letter, but before I typed it up, I was gonna ask you, this evening, is it a possibility to move forward with litigation, or would it be best to just go ahead and just send the GB2 letter to see what happens, and then just kind of move on from there?
Did they say they're going to delete it though?
Nope.
They say they're going to cease communication.
They said they're going to cease communication, but it's reporting correctly, and they're not gonna change the status of it as far as the reporting to the the credit reporting agencies.
Well, after the night, you're gonna wait a month, see if it's marked disputed. You can do that.
Now I think it's showing disputed. If I have to pull a file up again, but I'm pretty sure that it's showing. When I went and looked at it, it is showing disputed, but they're saying that they're going to cease communication, but they're not going to change the status. And then they sent back all of those, those credit card billing statements, but it's no validation of the debt. Of course, because of course they don't have it, but they didn't send it.
Okay. Well, question I have is, was it within 30 days of initial communication notice?
Nah, this was an old one. So, well, I take that back now. Technically speaking, it's an older debt on the credit report, but as when I asked her, she doesn't recall receiving anything from Midland in regards to these particular debts.
You said 1692 GB, okay. All right, well, I mean, it could, okay, well, it's possible, it's a big company, it's possible they never sent her anything. They certainly seem to treat it like that, but they could be just responding to CFPB. But your question is, does that person sue?
Yeah, I'm kind of thinking and more of going on the offensive mode, but I was just gonna ask your opinion. What did you think would be our next move?
I would have to know more. What would you? Well, I sue for violations, so you got to sort of tell me. I would have to know more, but what would you? I mean, we sue for violations, so what violation we have here?
Well, the first violation is they hadn't validated debt, and they hadn't ceased reporting and collection, so that in itself is a violation.
Is it within 30 days though? I mean, we're not too. I mean, we have to be sure.
Now that would be, like I said, that would probably be the only thing, because when I pulled it up and when I initially got a credit report, it was older debt. It was like from 18 and stuff, like when it charged off. So
yeah. So
but to say if she got the initial communication from Midland or not, by her assessment, she's saying no. So
okay, well, okay, well, I wouldn't sue personally. I wouldn't sue just on that, what you're telling me, because I would hate to be way deep in that, and then, hey, look, here's the letter we sent to your person.
Yeah, I got you.
Oh, I forgot about that. I was hoping to hear more, I don't owe this amount, or it sounds like y'all need to do a CC, man, because I don't give you things, I don't make up stuff for you, so I'm just listening. And unless that person I haven't heard you say this person told me, I do not owe that. I do never You know, so y'all might need to try a CC, and they've already said they're not going to communicate. And let's see if that's the case. But I would have her think very hard to see if she's ever received a miscommunication. Technically, they're going to try to say what they sent was a verification, even if she didn't.
Yeah, and I followed it. I was thinking either the GB2 or the CC. It's been kind of hard. You know, it's a husband and wife, customers I got. The husband, you know, all on board, and she kind of like, whatever. You know what I'm saying? And I'm like, you the one that's got all the connections. So we got some opportunities here, but you just got to let me know what's going on, and you got to like tell me what's happening so I can help you. And that's kind of like, you know, what I'm getting. So
yeah. So do you have the credit card deletion package?
Yep.
Okay. Well, you know, you should have used the credit card deletion letter. GB, you know, it's a credit card deletion letter for this scenario because it's a credit card debt, Midland. So just for reference, when you see this, when you have that package, if you have that package, it's most appropriate for these collections that are credit card charge-offs and all that.
Yeah, I did, and I noticed that like the day after I sent it.
Okay.
And I was like,
That's
yeah.
I mean, if I were you, I would even go so far as to go ahead and send that letter 1 credit card deletion back to them, certified mail, and try to get those documents that's listed in that credit card deletion.
I got you. Kind of just maybe just, you know, backtrack our steps, go with the credit card deletion letter, and then just see how they follow up after that.
Because if they have it, I mean, still they probably just have statements, but they still can cooperate, and I would copy it to CFPB again. But I would go through the credit card deletion process on that one.
Okay, cool. I can do that. That's no problem.
All right.
And then, like I said, I just get up with you on those other ones. I got everything documented, so they.
All right.
I know one of them cut and dry. So.
Okay. Anyone else have any questions about what we talked about?
I got one.
All right. Who's that?
Real quick.
Yeah.
Candace.
Who's this? All right.
This Candace.
I know. Okay.
Oh, thank you, Jesus.
Oh. Okay, so before I joined the group or whatever, I had sent my own debt validation letters to 3 creditors. I sent it certified. I know they got it. I did not get a response from them at all. Like, they were collectors. One is Diversified Recovery. Another one is,
They call them creditors.
Oh, I'm sorry, not creditors, collectors.
All right. Okay.
Like debt collectors.
Right.
They're not the original creditors anymore.
Yeah.
But I didn't get a response from any of them, and I know they received it because I sent it certified. So I'm wondering, is it worth it to send the 1692 GB like to them to see if I can get a bite from them, or just let it die?
Tell me what you sent them. Like, what did you say?
Well, my letter. Hold on. Let me see.
Let me drink some water before you read it, because I'll tell you.
Okay, I had a call coming in. So there's one of the ones that I kind of found online and modified it. It was like, are they allowed to collect in the state?
Who cares? I'm sorry. Go ahead. Okay, go ahead and read it. Let me get some water while you do it. Go ahead.
Okay. All right, I'm opening it up now.
There's a water in my mouth. I might shut up.
If my word would open up for me. Bro, the computer is being so slow.
Are you related to Candace Owens?
Don't do that to me.
All right.
I'm familiar with her, and no, I'm not related.
I'm just messing with you. That'll make me mad.
It
Man,
burns
them-
me
them-
if she has my name.
Man, them fighting words, Brian.
I'll be honest with you. If anyone
Right.
misleads me, I will.
Right.
I don't even want to. I don't even want that name mentioned. That's warranted.
Okay, so in my letter, I said to them, this is the one that went to Diversify Recovery because they was leaving me like all these wild voice messages or whatever. So I told them I received the voicemail. I gave them the date. I gave them the name of the representative that called me and left the message because he left his role, like, wilding out message, talking about something, we're going to come to your job. We're going to do all this. I said, I don't know who he is. He didn't identify, he never identified his purpose for the call. And so I said, please provide me with the name and address of the original creditor, an original contract bearing my signature, that there is a contractual obligation in which is binding for me to pay. I said, provide for me confirmation of a proper and legal assignment of contract granting you the authority to collect this alleged debt. I asked for them to ask for proof of their agency, that their agency is licensed to collect in my state, asked for full line-by-line transaction history of the original account, and then I also asked for them to provide me for proof of the last date of payment. And I didn't hear anything back.
All righty. Is it deleted off the credit report?
It's still on my credit report.
You know why it's still there?
Huh?
You know why it's still there?
Do I know why it's still there?
Yeah.
Because they ain't paying me no mind. I have no idea.
Who can tell her why it's still there?
You know,
Probably
cease and
because she didn't
desist.
tell them to delete it.
No cease and desist.
Who's that? Who's it?
Leroy, no cease and desist.
Well, yeah, I didn't specifically say.
I mean, once you tell them what you want, you have to tell them what action you want them to take.
So you want to know about their driver's license?
He's not asking about the debt. You're not challenging the debt.
Actually, you're right. I didn't hear anything challenging the debt either.
No, I guess I didn't do that.
You want to see their license?
So I should still send the GB? No, well, all right, I was wrong. So this is before I had education with y'all, telling me. So I should still try to send the GB and then instruct them to delete it with like the language within that letter.
What do you think?
I mean, I would think yes, because that's the one off my credit.
I think yes too. I think from here on out, you got to tell people what you want in life, not just in life, right? Let them know what you want.
Okay, that makes
Fine.
sense.
When you
I
go to
got a
McDonald's,
question.
ask them for their license to cook, permit to cook, and then walk out. Walk back out hungry. Okay.
And I got a question.
Okay, Candace, so you got it, Candace? All right.
Yeah, I got it.
Okay, cool.
I got it. I'm gonna redo it. Thank you.
Go ahead, Muzi, Houston.
Yeah, it's a little off from FDCPA. It's more about FCRA. Can we use the reports from IDIQ? Can we send them to the bureaus or to the creditors and collectors and tell them about the violations, the dates of last activity? Are they worth it? Are they acceptable by the bureaus or the creditors and the collectors?
Yeah, you can send that as an exhibit that you want to discuss. You can highlight it. You can say, look at this, and yeah, absolutely. You can send it.
Yeah, but if you look at the reports from annual credit report, which the clients are getting every 7 days, the dates of last activity, which we normally dispute, are almost the same on all bureaus. compared to IDIQ, which are different. So will they accept it? If I send it to the bureaus and say, you know what, the dates of last activity or the date opened or the amounts or all that stuff, is it acceptable to the bureaus?
Yeah.
Or to the creditors?
Yeah, you can use it.
I mean, because they can come back and say that, you know what, we did not provide that information to IDIQ. We provided what.
Say it. I mean, somebody gave it to them. They gave it to them. Yeah, but absolutely.
Okay.
Listen,
Hey Brian, did you say before? Did you say before that the credit agencies they just have disclosures and then
hey man,
the third party is the real report, right?
It's Leroy, man. I'm gonna get Leroy. Leroy to.
So it's a good report.
Green. Yeah.
We shouldn't have a problem because when we look at the reports from TransUnion or Experian and Equifax, the dates of last activity or the first delinquency are almost the same, but they are not the same on IDIQ reports.
All right, so listen, what Leroy was saying was those IDIQ reports are real credit reports. So what Equifax has on its records and what it's telling IDIQ is two different things. We're concerned about what they're telling people, not what they're holding in their pocket. So the IDIQ report is much more significant than you looking at a consumer disclosure, which there's a difference. And
okay.
So,
excellent.
Yeah. So, but I encourage you. You got the book, and I'm looking out for your.
No, I got your book.
You get the bonus letter.
Do you have a like an ebook version, or do I have to get the?
Yeah, I think the bonus letter includes the ebook version.
Because ebook is better. I can copy and paste your letters instead of the book.
Well, the copy and paste the letters. I'm sending you letters in Microsoft Word, where all you have to do is jump on there and.
No, I'm with your WhatsApp group, so you know I'm.
Yeah.
The weekly.
You have an editable letter. The bonus letter, the link I'm sending you, will include editable, I think.
All right. Perfect.
Yep.
Thank you, buddy.
All right, no problem.
Hey Brian, I have one question.
What's that?
Leroy.
All right.
Okay, I just had NV just popped up on my report, and it's like a old cable bill, but they the date on it says it's open is like June 10th, right? But the count is like 2 years old, so it's not the original count when it was open. So I'm trying to see, is that a violation because they reporting it? Is that false information? Like,
get our cousin number. He do landscaping. That's a business. He got a business. He'll come over there, girl. You'll be looking like shit.
Still on Leroy?
yeah. Can you hear me?
Yeah.
Yeah, I was trying to see because the original date when the account was open was like 2 years ago, but they just reported it on my credit on a consumer report as being open on June 10th of this year, 2020.
Yeah, if it's inaccurate, yeah. It's the RA violation. Yeah, FCRA.
I'm saying, so is that like a false information?
Yeah, it could be E8 off the gate. Is that debt collector we're talking about?
Okay.
Is that debt?
Yeah, it's a debt collector, LVMV.
Yeah, E8 off the gate.
Okay. Because I ERC had it first, and then they shopped to someone else, and I got it off with them. I got off with both of them. Now LVNB put it on there again with updated, re-aged. I guess you could say re-aged, pretty much.
All right. Well, but yeah. Anybody have any other questions?
Right. So the ones that you don't get in this week, are you gonna be doubling back so we can if we get the clients that's had their money ready for to do the individual like next week?
Well, remember we're not doing clients right now, really.
Okay.
So
that scratched that period.
Yeah, we just focus on getting y'all money so y'all don't cancel on.
That's what's up. Okay. That's what it is. That's where we at.
Everybody, I gotta get everybody. So y'all gotta hold tight.
I'm ready for mine, Brian.
Hold tight, because if you're outside looking in, it costs a lot of money. I don't do cases on contingencies like that. About $5,000, $1,500, something. So y'all hang in there, because I'm doing these cases to get y'all money. We'll get with your clients on next go round. And I promise y'all, all y'all have a case. If anybody on here, I think one person, I think Richard said they don't have a case. But if you don't think you have a case, you ain't looking close enough on your credit report. And guess what? That means if you got my book, it's like 40 something CRAs. So you pull your core logic report, you pull that LexisNexis report, all of you have a case. All of you have a case. All of you probably have at least 10 cases. But yeah, right now we're not doing outside clients and I gave you an opportunity. I actually had a whole lecture about how to get money off of your clients. And I don't think anyone really even bought that. The things you need to do that, you'll need a power of attorney, you'll need an assignment of claim to make money off of your client. So unless you already have an assignment of claim or something like that, no one's sent me, no one's emailed me saying, hey, I already got an assignment of claim. So you would need a few things to make money off of your client anyway that you may not have. But right now, we're just trying to get you all's claim so that y'all be straight.
So Brian, at present, has anyone in the group gotten any money from their demand letter with inquiries?
I don't know. Has anyone on here got any money yet from your demands?
I just started sending them out. I didn't see anything back yet.
Anybody got any responses? I think someone told me they got some responses saying XYZ. I don't know. Not I'm aware of. You can go in the WhatsApp group, maybe see if anyone has gotten any negotiation going yet.
Okay, because I was just curious because I got 3 of them I'm sending out tomorrow with the inquiries.
Yeah.
Oh, I did have a quick question. For one company, they did 2 inquiries on me like back to back, like within 2 days of each other. I don't know how I missed that, but I looked at my credit report and it was like, one was like on the one day, like on the 15th, and then the next inquiry was like on the 17th. Would that be considered like 2 different demands? This was a car it wasn't Capital One. It was one of them car people that I don't know. It was a bad day, but they really ran through my credit with a whole bunch of inquiries when I was trying to look for a car one day, and that was kind of me not paying attention. But it is what it is. But it was one of those car people. I can't remember which one it was. It wasn't Credit Acceptance because they did it too, but it was another company.
Okay.
Brian, a quick question. I just got my credit reports not too long ago, and I have some soft inquiries, but they're not mine. What it looks like they did. My daughter and I had the same name, and they put her stuff on my credit.
What you gonna do? What you gonna do with it? Impermissible inquiry letter, right?
Even if it's a soft inquiry?
Yeah.
Really? Okay. Okay. That's 3 of them.
Yeah.
Okay, great.
You know it, y'all.
Thanks.
So, all right, y'all. So yeah, we really are working hard trying to get these things done. Make sure you do, utilize. You got a lot of tools right now. You got a lot of tools. You have a lot of CR. Start your demands, get your letters out, get those responses, scan them in. Start creating your file, and we're just, all this stuff is going to work together to make your case solid, or more solid for those that start already solid. And we're gonna make it happen. So, all right. So look, we're gonna wrap it up. May have another session tomorrow, or what's that? Day is Tuesday already. Yeah. Maybe another tomorrow. And we'll do another topic and maybe follow up with some things. We may talk about the oral version of this E8 that you can do about call recording. Okay. Well, everybody have a good night. I'll see y'all.
All right. Good luck.